My name is Aidan Reay. I practice at King's Chambers in Business and Property team, and this is the final King's Young Professional Series webinar for this year. But for those of you who are eager, early in the new year, my colleague Oliver McKenty will be talking about recent developments in commercial ADR, and there will also be a new programme of King's Young Professional seminars coming out at some point in the new year. As we're reaching the end of the year, it seems like an appropriate time to do a contract law update to see what has been happening in the world of contract law in 2024. Now, obviously, there are lots of contract law cases in any given year, so I apologise if your particular favourite isn't here. What I've tried to do is select 4 cases to talk about and a 5th one to mention, which I think will be of general use and of general interest. So the 4 cases that I'm going to talk about are MUR Shipping BV and RTI Limited, which is a Supreme Court case, Bellini NE Limited and Brit UW Limited, Court of Appeal case, King Crude Carriers SA and Ridgebury November LLC, which is another Court of Appeal case, and Standard Chartered PLC and Guarantee Nominees Limited, which is a High Court case, but which was heard by a divisional bench. There's also the 5th case that I'm going to mention, but I'm not dealing with, which is Drax and Scottish Power. I'll talk about that one very quickly and explain why it's getting ignored. Drax Smart Generation Holdco Limited and Scottish Power Retail Holdings Limited was a Court of Appeal case this year which considered the requirements for a breach of warranty claim under an agreement for the sale and purchase of shares. So where the ability to bring a claim is curtailed by or limited by the requirement to serve a notice within a certain period of time, how does one go about looking at and interpreting that notice, and what does it need to cover? The Court of Appeal considered, and the specific question it was considering, was whether a notice which failed to claim the correct loss was nonetheless adequate. So what the notice did was the notice claimed losses which in fact were losses suffered by the target company, rather than a claim for diminution in value which was suffered by the purchaser. The claim was initially issued in that way, but by the purchaser, and then they sought to amend in response to a summary judgment strikeout application in order to correctly claim diminution in value. The Court of Appeal allowed the appeal in favour of the purchaser who was bringing the claim and gave general guidance. But I'm not going to talk about that in too much detail because I gave a talk about that back in October, and if you are particularly interested in it, the recording of that talk should be available on the King's Chambers website. So, first case I'm going to talk about is the Supreme Court decision MUR Shipping BV and RTI Limited. Now, this case, as the name probably suggests, and indeed a couple of these cases, was a shipping case, and it concerned shipments of bauxite from Guinea to Ukraine, and the charterer in that case had become subject to sanctions via its parent company being sanctioned. And the question that the Supreme Court had to consider can be distilled down to quite simple facts, which is where A has a contractual obligation to pay B in US dollars, and A becomes subject to a sanctions regime which will significantly delay any payment being made in dollars. But A offers to pay B in euros and to indemnify B against any costs of converting the payment into US dollars and any losses sustained as a result of the need to convert. But B refuses to accept this and contends that the contract is suspended due to the terms of a force majeure clause. Can B do this? So can B say, you can't pay me in US dollars at the relevant time? Because of the circumstances surrounding that, it triggers the force majeure clause, and I'm entitled to suspend performance in circumstances where A's response to that is, well, look, I'll pay you in euros and I'll compensate you for any costs or losses that you incur as a result of being paid in euros rather than in US dollars. Now, the arbitrators, in this case, said no, said the ship owner couldn't rely on the force majeure clause because the force majeure clause specifically required that the force majeure event be one that cannot be overcome by reasonable endeavours from the party affected. And the arbitrators took the view that the refusal to accept the offer of payment in euros, coupled with the indemnity against any costs or losses caused thereby, was a failure on the part of the defendant in the arbitration, the ship owner, to use reasonable endeavours to overcome the force majeure event. That decision was appealed to the High Court, and the High Court overturned the arbitrator's decision, saying that the ship owner could use the force majeure event. That decision, in turn, was overturned by the Court of Appeal, who reinstated the arbitrator's decision on a 2-to-1 split, with Lord Justice Arnold dissenting. The matter then went before the Supreme Court, and the Supreme Court overturned the Court of Appeal's decision and reinstated the High Court's decision. In all of these things, it does matter, I think, how you frame the question, and the way in which the Supreme Court framed the question was whether the exercise of reasonable endeavours may require the party affected, if it is entitled to rely on the clause, to accept an offer of non-contractual performance from the other contracting party to overcome the effects of the event or the state of affairs in question. The Supreme Court gave a single judgment. It was judgment of Lord Hamblin and Lord Burroughs, with whom Lord Hodge, Lord Lloyd-Jones and Lord Richards all agreed. And they answered the question in the negative. A party seeking to rely upon a force majeure clause does not have to accept an offer of non-contractual performance. The judgment of the court sets out the reasoning for this on a number of bases, but the starting point for it all, and this is a point of general application it's worth being aware of, is that the Supreme Court held that all force majeure clauses, unless, presumably, although they don't say this, expressly drafted to exclude it, imply an obligation on the party relying on the force majeure clause not to have been able to avoid the force majeure by taking of reasonable steps. Now, in this particular case, that was expressly set out, but even if it's not, they reviewed the authorities and said it's a necessary implication. And the reason it's a necessary implication is because of the rationale. And this they set out at paragraph 36, and they accept what was contended for by the Charterers' Council in front of them, which is that the rationale for such an obligation, whether it's express or implied, lies in causation, because the force majeure event does not prevent performance. So it's not causative of the inability to perform, if, by acting reasonably, one can avert the failure of performance. So, fairly straightforward. If you could take reasonable steps and it would stop the force majeure event from preventing performance, the force majeure event is not preventing performance. In my mind, there's some question mark as to whether or not they correctly characterise that as a question of causation, or whether or not it's better thought of it's that there's simply no force majeure event because the event won't have the necessary qualities. But either way, one can understand the ultimate rationale, which is that the force majeure won't act if you, taking reasonable steps, can avert the failure of performance. The performance then has to be looked at, and this is the next stage in their analysis, where they say that the performance in question is determined by reference to the contract, and you have to look at the parameters of the contract to determine what performance is being prevented. That was set out paragraph 37. And once approached from this basis, the Supreme Court said at paragraph 39 that it would be absurd to say that MUR, the ship owner, causes the non-performance of the contract, the failure to be paid in dollars, by failing to accept an offer of non-contractual performance, the offer to pay in euros. And the Supreme Court go on to then justify that by two other points. One is that they say that this is consistent with freedom of contract, in which your freedom of contract includes the freedom not to accept an offer of non-contractual performance of the contract. And unless the contract makes clear that a party has given up a right granted to it by the contract, the courts will not consider that they are required to do so to avail themselves of the benefit of force majeure. The second justification for this, they say, is that certainty in commercial terms is supported by adopting the approach that they adopted, because decisions on force majeure must be taken quickly, and it cannot be workable if you have to consider whether an offer of substitute performance might be acceptable. So if you, as the party seeking to benefit from the force majeure clause, have to ask yourself, is this offer of non-contractual performance something that a court thinks that I ought to accept or ought to have accepted it? This makes it difficult for you to make a decision as to whether or not you are going to avail yourself of the rights under the force majeure clause. And so actually what you need in this scenario is a relatively hard and fast rule, and that promotes certainty. I can see the reasoning behind that. I can see the rationale behind that. It does, though, seem to me that there might be a question about, well, look, in this case, it went to arbitration and we got one decision. It went to the High Court, you got another decision. Went to the Court of Appeal, you got the arbitrator's decision again. And it went to the Supreme Court and you got a different decision. In theory, now you've got the Supreme Court decision, you've got your certainty. But you always have this situation in which that's fine when you're dealing with a situation exactly like this one. But in other situations, you may still find yourself as a litigator, as an legal advisor, having to answer the same question. And how does a commercial operator trying to make a very snapshot decision determine these technicalities? I'm always a bit wary about whether or not legal certainty, as identified by the higher courts, actually corresponds with commercial certainty as businessmen making the decisions might need to make them. But that is the decision that the Supreme Court has given, and one can certainly understand the rationale of it. There is, within the decision, one little nugget that I anticipate will be widely trotted out by people in cases across a wide range of scenarios, which is that it was said at paragraph 58 that it is not unmeritorious or unjust to insist on contractual performance. All the more so if being precluded from doing so would introduce uncertainty contrary to the expectations of reasonable business people. The Supreme Court said this, referring back to Lord Justice Arnold's dissenting judgment in the Court of Appeal, which had started by saying that MUR's position looked wholly unmeritorious. He nonetheless upheld their position, but was overruled by the majority there. The Supreme Court actually is not unmeritorious. There's nothing unmeritorious or unjust about insisting on your contractual performance. And so I anticipate that when people are trying to hold others to the letter of a contract, this will be brought out and said, well, look, they say that this is unfair. They say that this can't be what we all have intended. But this is what it means. And actually, there's nothing unmeritorious or unjust in us insisting on the contract being operated according to its terms. So I think there's a useful takeaway there for general application. The Bellini Eni and Brit UW Limited case concerned insurance for business interruption caused by COVID-19. And it was a situation in which the insurer had denied liability on the basis that the cover responded only to damage arising from a notifiable disease. And damage was then defined as physical loss, physical damage, and physical destruction. Now, claimants argued that if this was the case, if that was the limit of your cover, the cover was actually illusory, because how would a disease ever cause physical loss, physical damage, or physical destruction to your business? And so they argued that the policy should be rewritten by the court to provide non-damage cover. Now, this was not a situation in which they were able to say that there needed to be rectification as a result of a mistake. They were saying, rewrite the contract because it creates an absurdity, they said. The Court of Appeal rejected the claimant's appeal. What the Court of Appeal ultimately said was nothing had gone wrong with the wording. The cover provided was the cover stated, and so there was no error that needed to be corrected. In terms of more general application, the case is interesting because it offers a recent discussion of when and how an error can be corrected by construction. It doesn't change the law, it doesn't say anything particularly new, but what it does do is it confirms the existing authorities and the existing approach that was originally set out in Eastern Pantile by Lord Justice Brightman back in 1982 and was subsequently affirmed in Chartbrook Limited and Persimmon Homes Limited in 2009 in Lord Hoffman's judgment there. There are two conditions to correcting an error through construction. The first condition is there must be a clear mistake on the face of the instrument. So you must be able to look at it and say, yes, that's clearly an error. And the second condition is that it must be clear what the correction ought to be in order to cure that mistake. Though this is something I find that comes up relatively regularly because your alternative is pleading a claim in rectification, which requires you to either satisfy the requirements of a common mistake or the particular requirements applying to a unilateral mistake, and the limited circumstances in which that can give rise to rectification. And often there's an evidential difficulty. In showing that there was an expression or as to what it ought to be that the mistake can be identified from. Often the evidence is that the parties had understood. People say, well, this is what we understood, this is what they understood. But actually explaining how and why everybody understood that. And it doesn't mean that anybody's not telling the truth, but within the midst of time and the fog of the negotiation and how things actually played out, trying to show how and why, absent written correspondence that shows it, that mistake came about can be difficult. And so sometimes people say, well, look, let's just say this is obviously a mistake and we're going to construe it away. It's important, therefore, to be cognizant, I think, of the conditions for doing that. And whilst that can be done, there's clearly limits upon the scope for doing it by reference to those conditions. Third case I'm going to talk about is King Crude Carriers SA and Ridgebury November LLC. Now, one thing relatively hot off the press to note is that permission to appeal on this case to the Supreme Court was granted on the 28th of October. So there is likely to be an appeal on this. And so what I say about this case remains the position for now only. The case concerned whether there was a principle which was referred to by the Court of Appeal as the Mackay and Dick principle, that where a party's obligation to pay a debt is subject to a condition, and the putative debtor wrongfully presents that condition from being fulfilled, the condition is nonetheless treated as dispensed with or fulfilled, with the result that the debt accrues. So if a sum of money is going to fall due for payment, but there are conditions that have to be satisfied under the contract before that sum of money is due for payment, and the person paying wrongfully prevents those conditions from being fulfilled, does the debt still fall due? At the arbitration in this case, it was held that such a principle did exist. On appeal to the High Court, the court said there was no such principle. The remedy, the High Court said, sounded in damages rather than in debt. So it wasn't that a claimant in this scenario had no remedy. It's simply that their remedy is for breach of contract and damages suffered, rather than a claim for debt. In the case, the issue arose because the buyers of 3 ships had failed to provide the solicitors who were due to open an escrow account with the necessary documentation. It was know your customer documentation and a signed escrow agreement. They don't provide that. The obligation to pay the deposit into the escrow account under the terms of the contract was only triggered once those things were done, because it was only once those things were done that the solicitors operating the escrow account could then say that the escrow account was up and operating, and it was only at that point that the obligation to pay the deposit for the ships was triggered. So that never happens. The deposit is never paid. The sellers for the ships bring a claim for debt and for damages. there is a preliminary issue determined as to whether or not a claim for debt arose. And this is important because the notices for termination refer to the non-payment of the debt, and so it impacts the validity of those notices. But also, the ships were being sold, it turned out, in a rising market, or at least that was the claim on the part of the would-be buyers. And so they said, actually, your claim lies in damages, and you've suffered no loss because you were able to go on and sell the ships for more money than you were going to sell them to us. That would have been a valid defence to a claim in damages and would have reduced to zero, potentially, the amount that would be owing in damages. But it wouldn't impact a claim for debt. The Court of Appeal agreed with the arbitrators that the Mackay and Dick principle did exist. The court formulated the principle at paragraph 84, and this is how it formulated it. It said, an obligor is not permitted to rely upon the non-fulfillment of a condition precedent to its debt obligation, where it has caused such non-fulfillment by its own breach of contract. So far, so good. They then go on to qualify that. At least where such condition is not the performance of a principal obligation by the obligee, nor one which it is necessary for the obligee to plead and prove as an ingredient of its cause of action, and save in so far as a contrary intention is sufficiently clearly expressed, or is implicit because the nature of the condition or the circumstances of the case make it appropriate. So it is a principle, except where it's not a principle. The Court of Appeal formulated a juridical basis for this principle, which is useful because, as a general rule of thumb, when a principle is referred to as the principle in a given case, that rather suggests that one is struggling to find a clearly expressible legal basis to explain the principle. They said the juridical basis lay in the presumed contractual intention of the parties, and they said the conditions for the principle to apply were: 1, there must be an agreement capable of giving rise to a debt rather than damages. Fairly obvious. 2, there must be an agreement that the debt will accrue and or be payable subject to fulfillment of a condition precedent. Again, that would seem fairly obvious. These are precursors, so I don't see how you could have this argument without those conditions being satisfied. And 3, there must be an agreement that the obligor will not do the thing which prevents the condition precedent being fulfilled so as to prevent the debt accruing and or becoming payable where that agreement is pursuant to an implied term of cooperation or an express term. It was then said that the natural presumption arising from these conditions was that the obligee should have the benefit of the debt for which it has bargained. Why did the Court of Appeal conclude in this way? Lord Justice Nugent gave a short concurring judgment, and he sets out the motivation at paragraph 106, where he asked, what is the position if the buyer does not only not pay the deposit, but does not even do what he is obliged to do to enable the account to be opened? And I think when you ask the question in that way, and this comes back to the point I made when talking about the Supreme Court decision, it all really depends on how you frame the question that you're going to answer. The answer that the Court of Appeal gives does start to look understandable, because the answer given to that was that it was difficult to suppose that the parties had intended that it should make all the difference. It shouldn't make all the difference between whether the deposit was due or not, whether or not the person who was going to make payment performed the preconditions that they had, satisfied the preconditions they had to satisfy in order for that payment to fall due. Now, I can understand that, but I can also see why the Supreme Court would be interested in this, because I can see a gap then opening up, because what you have is a situation where there is a period of time between completion and the obligation to make payment of a deposit, and you have a precondition to the obligation to make payment of a deposit falling due. Does the Court of Appeal's decision in King Crude Carriers also mean that you couldn't renounce the contract. Because what you have is the Court of Appeal saying, well, if you don't fulfill the preconditions, you're still going to be liable to pay the debt. Okay, so if you're in breach of the preconditions, you can't rely upon those preconditions to avoid a claim for debt. But does that also mean that you can't renounce the contract before the preconditions have to be satisfied, or at the time the preconditions have to be satisfied, such that the debt doesn't fall due? There's nothing in the Court of Appeal's decision which suggests that that's the case. There's nothing there which suggests that the buyer couldn't turn around a day later before the obligations were triggered, or at the time that the obligations were triggered, to provide know your own customer information and to provide signed copies of the escrow agreement, and say, actually, I'm renouncing this agreement. I'm not going to perform it. Come and sue me in damages. Yet, if that is the case, if you can do that, it creates something of a strange difference to my mind, or a strange division, because if you do that, you're liable for damages. But if you merely breach your obligations under the preconditions, you're still liable in debt. That seems to me to be a difficult dividing line to hold. Why would that be the case? I also think you have to, and this comes back to the freedom of contract point that the Supreme Court mentioned in MUR, really. If the parties have contracted for the deposit to only become payable upon certain conditions being fulfilled, and they've contracted for a situation which is going to be a period of time between completion and deposit, rather than the deposit simply being payable immediately upon completion, that's how the parties have allocated the risk. And they've allocated the risk of non-compliance, it would seem, in such a way that it falls upon the seller, in the sense that the seller's remedy would lie in damages, not in debt. When you interfere with that, and the reason which Court of Appeal say you interfere with it is they say, well, there's an implied condition, implied term here. You're altering that risk. And the question then becomes, well, is that implication necessary to give business efficacy to the contract? Is it so obvious as to go without being said? I can see why you might say it's certainly not necessary to give business efficacy to the contract, because you can still have a claim in damages. But I can see why you might say, well, it's so obvious as to go without saying. Had the parties been asked what this was, they would say, yes, of course. But that's always a difficult determination, in my view, because what you have is a seller who wants to say, yes, of course, that's what we would have said. And a buyer will say, well, no, that's not what we would have said, because what we contracted for is what we were contracted for. And these are not agreements which are put together on the back of a cigarette packet. These are quite detailed, complicated, professionally negotiated legal agreements. And the parties are entitled to do the things that they're entitled to do, or required to do the things they're required to do under them. And to imply additional obligations to affect the parties' contractual rights, and in particular to bring forward the accruing of a debt, seems to me to be difficult to understand. So I can certainly see why that question will benefit from further consideration for the Supreme Court. The final case I'm going to talk about is Standard Chartered PLC and Guarantee nominees. This is a High Court decision. I normally, when I'm doing this, try to avoid High Court decisions because there's a multiplicity of them. But this one dealt with a question which I think it may or may not go any higher, but it does have a degree of general application. And it's something that I've asked myself over the years when it's come up. And we now have an answer, so it interested me. The question here was how to interpret the provisions of contract which relied on 3-month LIBOR once that interest rate no longer existed. The specifics of it and the reason why it was heard by a divisional court is that this was a test case. It related to the effect of the cessation of the publication of LIBOR on perpetual preference shares which provide for the payments of dividends by reference to that rate. But I've seen what I think are broadly analogous situations in much less complicated scenarios where you have loan agreements or you have simple contracts which provide for interest by reference to a base rate or a certain amount above a base rate. But the base rate selected is not the Bank of England base rate. The base rate referred to is the base rate of a particular retail bank. And I've had scenarios where I've hunted in vain to see that retail bank has ever operated something that could be called its base rate. And if it did ever do so, it no longer appears to do so. So what do you do if it's 2% above a particular retail bank's base rate and that retail bank no longer has a base rate or never had one? The court described the approach in the authorities which it reviewed as, in general terms, being one which, when a contract is required to be performed in non-frustrating circumstances which the parties did not foresee and for which they did not provide, seeks to ascertain the purpose or structure of the relevant aspects of the parties' bargain and to adopt an interpretation which best serves or is most consistent with that purpose in the changed circumstances. And this was described as being, in effect, a form of contractual cypre. The court held that for contracts, the terms of the preference shares were subject to an implied term that if the defined rate was no longer capable of operation, a reasonable alternative rate should be used. And that, I think, is the point that is probably going to have the most general application. The idea that if the rate that you need to use no longer exists or cannot be found, a reasonable alternative rate should be used. Now, in the specifics of this case, the reasonable alternative rate was considered to be the CME term SOFR and adding the ISDA spread adjustment, which is somewhat of a rather complicated interest rate, but was found to most closely mimic the qualities of 3-month LIBOR. That's not going to be the case in the situations where it's a loan agreement or where it is a contract with a retail bank base rate. You're going to be looking at different alternatives. But what it does do is it says you do have an alternative. You don't simply say interest is impayable, or if it's 2% above base rate, a particular base rate, you don't say, oh, well, it's just 2%. You are able to go and say, well, this rate no longer exists, so we think it should be substituted for this particular rate. Now, that said, you might have to produce some evidence. You may get away on submissions with saying, oh, well, it should just be the Bank of England base rate. But if you want anything more specific than the Bank of England base rate, you're going to have to, I think, try and produce evidence that shows that retail Bank A's rate matched or was consistent with, within a certain margin of error, retail Bank B's base rate, which still exists and can be used. But I think that is something that will be of help going forward, where you have that situation where the contract provides, and there are lots of contracts actually which also provide for the use of LIBOR in circumstances where you might think, why did anybody think that LIBOR was a good idea in this type of contract? But they do. I've seen hire purchase agreements and things like that, which refer to LIBOR, where that does seem overly complicated for the nature of the agreement used, and this will be a case that one can rely upon in order to argue for an alternative rate in the absence of LIBOR. It's 10:38. That concludes my contract law update. If anybody has any burning questions, I think those will flag up in the screen for me if anybody wants to ask them. Otherwise, the webinar, as I said, is being recorded and will be sent out tomorrow. I think it's the intention to get it out by tomorrow, along with copies of the slides for you to digest and enjoy whilst having a mince pie over the Christmas period, if you so choose. But if when you get those, if anybody has got a burning question they would like to get in touch with me, they do feel free to do so. Otherwise, I would thank you all for joining this morning. And I would encourage you all to join Oliver Kenty's talk in the new year, which I think will be very interesting, on developments in commercial ADR, which is obviously something of a hot topic now, following on from the recent Court of Appeal judgment and how that will actually play out in practice. Thank you very much. Sorry, I thought I had a question, but it's just some thank you. So thank you very much for those of you who've posted those in the question box. And I will end the seminar, and I will wish you all a very good day. Thank you very much.